Welcome to The Explainer. Today, we're digging into what looks like a simple fight between a homeowner and her HOA over a tree. But trust me, this is way more than just a landscaping issue. It's a legal showdown that really peels back the curtain on how the fine print in your community's rules can lead to a verdict you'd never expect. And you're going to want to stick around because the final twist in this case, well, you won't see it coming.
You know that feeling, right? That official-looking envelope from the HOA shows up and your stomach just drops. Well, if you've been there, this story's for you. We're going to see how one little word in a policy, combined with the whole legal idea of proof, can blow up a simple problem into a really serious legal drama.
Okay, so let's set the stage here. To understand any conflict, you got to know who the players are. So let's meet the homeowner and the HOA at the center of all this and figure out how a basic neighborhood complaint escalated into a full-blown legal battle.
So in one corner, you've got the homeowner, Susan Jarzabek, and in the other, you have the Hillcrest Improvement Association, her HOA. Now, this all kicks off with a complaint about a tree. A neighbor isn't happy. But this isn't really about the branches. No, this thing quickly snowballs into a fight over hundreds of dollars in attorney's fees that the HOA just decided to charge to her account.
Well, Ms. Jarzabek was convinced that these fees were totally out of line. She believed the HOA wasn't just wrong, but that they had actually broken their own rules. So she didn't just write an angry email or, cut a check. She decided to fight back. She filed an official petition with the Arizona Department of Real Estate to challenge what the HOA was doing.
Okay, this is where things get really interesting. This entire legal fight, it all comes down to one single document. The HOA's own enforcement policy. And what's wild is that both sides read the exact same document and walked away with two completely different ideas of what it meant.
So here's the disagreement in a nutshell. The homeowner, Ms. Jarzabek, she's arguing that the policy is clear. The HOA has to give her 2 warning notices before they can call in the lawyers. But if you look at what the policy actually says, it's a bit different. It says the HOA may, not must, but may, escalate to an attorney. And at that point, the whole notice procedure just stops applying. That one little word may changes everything.
So think of it like this. The policy has a standard road, right? It's got warning signs and small fines along the way. But what it also has is this kind of secret escape hatch, a clause that basically gives the association the power to completely jump off that standard road, go straight to their lawyers, and then hand a homeowner the bill for the whole thing.
All right, so the rules themselves are a little murky. But what happens when you take all this into a courtroom? Let's go inside the hearing because this is where the paper trail, or, the lack of a paper trail, really takes center stage.
So check this out. The HOA's one piece of solid proof of an early warning, a certified letter, had 2 huge problems right from the get-go. First, they sent it to her husband, not to Miss Jarzabek, who is the only actual owner of the property. And second, it never even got there. The post office sent it right back marked unclaimed. Not a great start.
So at the hearing, it really just became a classic case of he said, she said. The HOA president gets up there and swears that, yeah, other letters were sent. But when the judge asked to see them, well, they couldn't produce a single one. They just weren't in the record. Ms. Jarzabek, on the other hand, was crystal clear. She had no idea there was even an issue with the tree until a scary letter from a law firm just showed up one day, a full 9 months later.
And you can see it right here in the judge's own summary. Her testimony was simple and it was powerful. From her perspective, it was just radio silence. No calls, no warnings, no friendly heads up. Nothing. And then bam, a lawyer's letter is in her mailbox, demanding action, and pretty soon, a lot of money.
So what do you do with that? You've got 2 different stories, and you've got a bunch of missing evidence. How on earth does a judge make a call? Well, it all comes down to a fundamental legal principle that decides cases like this every single day. It's something called the burden of proof. And all that really means is it's someone's job to prove their side of the story. In a case like this, the standard isn't like in a criminal trial. It's not beyond a reasonable doubt. It's just, is it more likely true than not? And this is so important. The judge's decision isn't about what feels fair. It's about who had the legal responsibility to bring the receipts. And here is the absolute key to this whole case. Because Ms. Jarzabek was the one who filed the complaint, the burden of proof was on her. Think about that. It wasn't the HOA's job to prove they followed the rules. It was her job to prove they broke them. And this quote from the final ruling says it all. The judge found that she lost because her whole argument was built on a rule. the 2 mandatory notices that just wasn't actually in the policy. Since the policy allowed the HOA to go straight to a lawyer, she couldn't legally prove they did anything wrong, no matter how unfair it all seemed.
So just like that, the judge dismissed her petition. Based strictly on the law and who had to prove what, the homeowner lost. It looks like a total, clear-cut win for the HOA, right?
But hold on. Just when you think it's all over and the HOA is celebrating, the judge does something fascinating. He adds a game-changing little detail. Not in the main ruling, but tucked away in a tiny footnote.
I mean, this seems pretty obvious, doesn't it? She lost the case, so of course she has to pay the fees that started this whole mess. But in the legal world, it's rarely ever that simple. And here it is, the big twist. In this footnote, the judge specifically says that this hearing was not about deciding if those attorney's fees were a valid debt. And then he says the court offers no opinion on that issue. Wow.
Let's just break that down for a second. The homeowner lost her argument that the HOA broke its rules. Period. That's all the judge decided. The ruling did not say the debt was valid or that she had to pay it. So that huge question, does she actually owe this money, was left completely unanswered by this court.
So, after all that, what are we supposed to take away from this? Well, this case is a masterclass in a simple truth. Winning or losing a dispute can come down to the tiniest details in the rulebook, and, maybe even more importantly, who has to do the proving. The big takeaways here are pretty clear. First, you have got to read the literal words in your community documents, because what you think they mean doesn't matter. Second, understanding who has the burden of proof is literally half the battle. And third, and this is the big one, losing a single legal claim doesn't always mean the whole war is over.
And that really is the question to leave you with, isn't it? If you're a homeowner, seeing how this played out, does it change how you'd think about a fight with your HOA? This case really proves that knowing the precise rules of the game, having your proof lined up, and understanding the legal playing field, that's everything. That's how you figure out where you really stand before you even make the first move.